Hello and welcome back to Drilled. I'm Amy Westerveld. This is season 14, Obstruction. We have been talking each week to the authors who have edited and contributed to a big, new, giant collection of peer-reviewed research on climate obstruction. It's from the Climate Social Science Network at Brown University, and it's called Climate Obstruction, a Global Assessment. For the past 11 episodes, we've looked at what climate obstruction actually looks like in different parts of the world, all the different tactics that are being used, the different people and industries that are using them, why it works so well, all of those things. In these next two and last two episodes of the season, we're looking at what efforts have been made to push back on obstruction and what has actually worked. So this is really interesting and exciting because we're now looking at peer-reviewed research on what actually works to stop obstruction, which is new research. And frankly, I'm kind of surprised that there's even enough of it to make for two whole chapters. Those chapters are focused on two key types of efforts: litigation and activism. Today, we are starting with litigation. So there are hundreds of court cases all over the world targeting polluting companies and industries from a bunch of different angles. And today, I'm joined by Joana Setzer from the London School of Economics to walk through what those strategies are and what is working. That conversation is coming up after this quick break.
My name is Joana Setzer. I'm an associate professor at the Grantham Research Institute at the London School of Economics.
What was the idea for doing this work in the first place? Why are we talking about litigation?
Great. So, if you think about this book, it's such a broad set of angles that are covered. And that's why I think it's a really important contribution. So what I see our chapter and the law more broadly is able to do, it's able to do a quiet revolution. So I think I see law and the state as countering this organized obstruction. And then we see also how obstructors might also use law to fight back. So it's a complex one. And we wrote this chapter together with Grace and Ben and several other contributing authors. The way we went about that was mapping these three big levers that show how law can puncture the playbook of delay and obstruction. And the three levers are regulation, litigation, and government investigations. So we go one by one, and there's lots of connection between them and the other chapters.
This chapter and the one on activism feel like so what can we do about it chapters. And I think helpful for people to know that there are things that can be done, that are being done, and it's not all just a one-way thing. So in addition to governments, what are the other groups of people or types of people who are taking these actions that you mentioned?
Yeah. So, the actors that are taking this action are very much a reflection of the very multifaceted group of actors that is a part of climate obstruction and of the efforts to fight it. So it's a whole ecosystem, right? You have the fossil fuel producers and the trade groups. You have the aligned sectors. You have PR firms, finance, political actors, media, and lawyers and NGOs, and of course the government. So all of these are involved in either litigation or legislation. So I think when I give some examples, you will see that. And again, the fact that law can be used both to obstruct and to counter obstruction is a reflection of this variety of actors. The other thing that I think it's important with legal responses is that you can only have legal responses if you have evidence. And therefore, the legal response is a reflection of the evidence that is available. And a lot of this evidence is produced by the science, so attribution science, and also by the documents that show where the obstruction took place. So the legal response depends on the investigation, and often even investigation by journalists to produce the evidence. So if we think about regulation and legislation, there are different functions that legislation and regulation have to counter obstruction. The first one is the most direct, I think probably obvious one, which is you pass a law to determine controls. So direct emission standards, targets, pricing, all of this we understand are also ways through which the law can fight or counter obstruction, because the moment that you set a clear target, a clear pricing mechanism, clear standard, you create a clarity that then actors have to respond. Of course, in turn, I'm going to always probably have to bring that other side. In turn, you will have some heavy pushback against laws and policies that set those targets. But we have a lot of also academic evidence that passing legislation is the most robust way to set intentions, but also the actual targets. And that has resulted in reduction of emissions. So legislation that sets targets is the most obvious one. But then other ways in which legislation and regulation are important are to deal with the issue of misinformation and transparency. So we have several examples of legislation that deal with greenwashing, that establish disclosure duties or rules for advertisement, and even what we call regulatory shaming. And the chapter brings several examples of national agencies that have penalties and that will expose firms for misleading claims, and also competition and consumer authorities that will point to, for instance, claims or eco-design that are vague, or carbon neutral offsets that are not substantiated. And then finally, through law, you can also try to deal with conflicts of interest. So we know that there is strong lobbying and issues such as revolving doors, and how both in the domestic context, but also internationally, we know now of how many lobbyists attend UNFCCC meetings, COPs, for instance. And through lawmaking, through regulation, you can also address these and minimize the ways and how often such conflicts of interest and lobbying will take place.
Okay. Can we talk a little bit about timeline and just sort of the evolution of litigation in particular? So you mentioned this in the chapter, and we've definitely covered this before too, that there was sort of this early batch of cases in the early 2000s, and then not absolutely nothing, but not much happening until this recent explosion in the last decade. So I'd love to have you talk a little bit about how many cases we're talking about and what are the things that have led to so many more cases being filed in the last decade or so.
Yes, definitely. Well, litigation is a very visible response to climate obstruction. And if we think in terms of numbers of cases, the Sabin Center at Columbia University collects all the litigation that is climate specific. And there are over 3,000 cases around the world in 60 countries. So there's now a really large number of climate specific cases. And these will deal with the problem of obstruction in different ways. So if you think about the first wave of cases in the US that dealt with, that were brought against the carbon majors seeking compensation, those were all unsuccessful. And it took time. And when I say it took time, it took also back to the issue of evidence. There was a need for more robust evidence and developments in law, and also in other countries, the law carried on developing for us to find ourselves in this moment that we are now, where we haven't seen yet one successful case that has obtained damages from these companies. Not so far. And the group of cases that we have now is qualitatively different and I would say closer to get that than the first wave. So what we have now is we have cases that are built upon the argument that these companies have historically deceived consumers. So it's really interesting to see in the US how the argument of deception, obstruction forms the basis for cities and states to seek compensation. So we have now around 30 cases brought by states and cities and tribes that allege that oil majors and trade groups, they knew, they misled, and they delayed. And by doing this, they have worsening the harm and the adaptation costs. This is very unique in the US. So in other countries, the basis for such compensation cases tends to be more on the emissions themselves, not so much on the misleading, on the obstruction. So the US cases they bring this issue of obstruction at the center of why, as a result of that, we have the problem that we have now. And these cases now have survived years of the companies trying to remove them from courts. And we have, for instance, the Honolulu case moved into phases of discovery and trial. So it's getting closer. Again, we haven't had a successful case seeking compensation, but they will be quite diverse also across these several cases, either focusing on public nuisance or fraud or consumer liability. There's even a couple of cases that are based on racketeer, so the RICO Act. And what it might be of these compensation cases is that we'll see trillions, billions of dollars, potentially these companies having to pay, not just because of the damages that they caused to the climate system, but also because they deceived and misled the public and shareholders. So this is one type of litigation that is very visible, but it's also important that not all litigation that is relevant for this issue of obstruction is of this type. So there are other examples that have already seen success. And here we have the climate washing cases, right? The core of climate washing, greenwashing is misleading information, is attempts to obstruct it to an extent. And here we have many hundreds of cases that have brought or challenged carbon neutral flights or fossil fuels that are marked as clean. And then also going beyond the carbon majors, you have cases against banks or also there are examples against the agriculture sector. So it's much more varied, the types of actors against who these claims are brought. And they are trying to get either a civil penalty or a corrective statement. So address obstruction from this angle of you've lied, you have to repair that lie. And we've seen a really high rate of success also compared to other types of cases in climate washing.
Can I actually have you talk a little bit about attribution science too, and the role that has played in strengthening some of these cases? How has that kind of come into the litigation mix?
Yes. So attribution science has been a critically important part of climate cases, particularly these that seek compensation. So the issue there was that with governments, to an extent, it's easier to file a case against the government because governments have duties because they've signed to the Paris Agreement, because they have duties of care that are established through legislation. And that's quite different from corporates who don't have commitments to Paris. They don't have obligations often to reduce emissions through legislation. And then moreover, also the fact that it is, in legal terms, it's not only necessary to demonstrate that a company has emitted, but you also have to demonstrate the damage. And how do you do that? Well, the way you can do that is precisely through attribution science. So attribution science is this science that will connect the increased emissions and the result of those emissions. Therefore, to what extent those emissions have increased the severity of extreme weather events, and then attribute that to specific sources. So that is absolutely critical in legal terms, because you wouldn't be able to ask Exxon or Shell, any company, to pay unless you can demonstrate that A, they've emitted and how much, and B, to what extent those emissions have contributed to that specific damage. And what's interesting is that attribution science was taking place anyway, because there are so many scientists that were working on that, because it's an important scientific question. And what was missing was how to translate those findings into the litigation, into the filings, and in a way that is sufficient proof for courts to be able to consider that as evidence. And this is what we're seeing now in the last few years. There was a really interesting paper that was published by Rupert Stewart-Smith and others, showing that actually there was an evidentiary gap, that the state-of-the-art science that existed already at the time they published the paper was not reflected in the litigation, which suggests that even the cases at the time could have done better if they had engaged with the state-of-the-art science. And this has changed because the lawyers are now better qualified, and they are paying more attention and really putting a lot of effort into understanding the science. And at the same time, the scientists, they realized that there was an opportunity to make their research useful and applied. And therefore, they started really understanding in what ways they could present those findings that they would have anyway, but in ways that could be understood by courts and understood by that language that is the language of law. And then this is all now what we are seeing now. And therefore, we have yet to understand what is going to be the use, how this will impact the findings of courts and experts in these cases. But we are definitely closer, thanks to the science and to this understanding of how to apply the science, we're closer to seeing this attribution being established, not only through the academic papers, but also through courts.
That's so interesting. Okay. You mentioned in the chapter that, most of this litigation was focused on the global north for a long time, but now there's been an increase in cases in the global south. Can you talk about that a little bit? What is litigation looking like in global south countries?
Yeah. So it's true that in general, it took longer for countries in the global south to start filing cases. And we can, of course, explore why, but the most obvious reasons is that it's quite expensive to file a case, and you need that expertise to understand the science issues at stake. So it took a while for the first cases to be filed in the global south compared to the number of cases we were already seeing in the US and in Australia. But in the last 10 years, there's been a really sharp increase, and the majority of cases have indeed been filed in the last 5 years in the global south, with countries such as Brazil, and we don't have a full account of how many, but in China also the number of cases dealing with climate issues has grown, but we haven't analyzed. There are more than 500 cases, for instance, that the Supreme People's Court of China has already mentioned that they are looking into, but we haven't yet looked. So the Global South has this both issue of coming a bit later, and that we still have to understand better and get hold of what this group of cases are. But the ones that we know of, they both reflect some of these trends in the global north. So you see cases seeking compensation, with the caveat that those cases are not a US city and state filing a case against a company, a major oil company in the US. We're here talking about individuals and communities in the global south filing cases against companies in courts in the global north. So there is this transnational angle that is fascinating that you see in some of this litigation. One of the best examples is the case of Saul Luciano Luia, the Peruvian farmer who files a case against the energy giant RWE in Germany. So this case has been recently dismissed, but it got all the way to the evidentiary phase. The judges looked into the evidence, into the attribution science, and while they found that there was not enough evidence to demonstrate that Saul's house wasn't at sufficient risk from the melting glacier flooding the house. It did confirm that in principle that responsibility would be possible. So again, it's a matter of time until a next case where the individual bringing the lawsuit, for instance, lives closer to where that flood would have happened could be successful. So interesting developments in this litigation dealing with damages in the South. And we have still ongoing cases, such as one that was brought by a group of islanders in Indonesia against the cement giant Holcim in Switzerland. And we are still waiting for that case to be decided. And then you have also lots of other cases that will address issues around greenwashing and misleading offsetting, and also cases that will deal with permitting. So the world of climate litigation in the South is evolving in parallel, but also with some really important decisions where you've seen already courts in Brazil, in Indonesia, and in South Africa giving decisions that protected either climate regulation or challenged the governments for being not implementing existing legislation, or also to implement adaptation policies that were not being implemented, just to give a few examples.
Fascinating.
And then I didn't mention, sorry, in the Global South, but then it's more towards that part of the investigations. So it's one of the examples that we discussed quite a lot in the chapter of then not legislation or litigation, but government investigations. There's a good example from the South, but maybe I can leave it for when we get to the investigations.
The Philippines, right?
Yes.
Yeah. I am going to ask you about that. Okay. So I want to talk to you about the international courts and the role that they play. And especially, I know that this chapter was written way before the ICJ ruling came out, but I'm curious to hear your take on, the importance that that ruling might have on litigation in general and like on some of the cases that are underway. So yeah, what role do the international courts play in general? And then how important is this ICJ ruling?
Well, it's a big question and it's very recent, right? It was only in July 25 that the International Court of Justice, the ICJ, issued its first ever advisory opinion on climate change. So specifically, the court was looking at whether states had obligations to address climate change under international law. And what is very obvious and very important already is that there's a conclusion that states have duties to address climate change, not only because they have to follow the Paris Agreement, but also because there are so many other laws and obligations under international law and human rights that make them then obliged to address climate change. And the second step is that not only they have that obligation, but that if they fail to act, they could be exposed to legal risk. Now, one of the first reactions that people had when looking at this ICJ advisory opinion was whether it would only apply to states. And now we're already seeing many scholars clarifying that, of course, that's not the case. That while the ICJ's advisory opinion responds to a question about the obligations of states, the moment that states have that obligation, it really trickles down into consequences that will affect the major emitters. So just for example, if a state is issuing a permit for new oil and gas, that is part of what this advisory opinion is about. So it will affect the major emitters, at least indirectly, but quite directly as well. And it might also shape the future of legislation, of what the next NDCs will be about, because there is this clear obligation for NDCs to be ambitious. And it might and likely will affect the future of litigation, because you have this signal from the highest court in the world that international law is converging and that countries are expected to act. So the consequences are really huge. It's extremely important advisory opinion that we are only starting to understand all its consequences. And what is most importantly is that we will start also seeing that reflected. So, for instance, we will see how it's going to be considered and affect the COP negotiations now in December and the NDCs and so on. So it's still a bit speculative how we're going to see those impacts, but they are very likely to be observable and to increase the legal risks for countries and for corporations.
Okay, so we've already talked about a couple of really interesting cases, but I'm curious for your take on, what are the cases that you're following right now or that you think are really important for people to kind of have on their radar at the moment?
So we already discussed some of these cases that are seeking compensation. And of course, they are important, but it's been many years that we're waiting for something there. I think that there are other cases that are more eminent and that I'm very interested in, and maybe cases that haven't received so much attention. And so one type of case that I've been particularly interested in following are these different types of cases seeking damages. So cases based on this idea of polluters pays, but that are not like the compensation claims that we see in the US that seek compensation for historical emissions. They seek compensations for climate damages as they happen. And so let me just give you an example to illustrate. In Brazil, there are now a few hundreds of cases that have asked for individuals or companies that have committed deforestation, illegal deforestation, to pay for climate damages. And the way they do that is by demonstrating that this area of forest that was burned, and you have the science, by burning, you have X amount of emissions. And those emissions in the market would cost X dollars per ton. And you multiply one by the other and you get to an amount that has it's pretty robust in terms of methodology. And while it might not be a huge amount in the millions and billions, it's an amount that is already painful enough to get these companies to consider carefully, or individuals, what the benefits are of burning the forest or emitting, let's say, if you're talking about a thermal or a coal plant emitting beyond what you've been authorized. So what I like seeing is these creative cases that might look into something that is more specific. So one activity, but by doing that, you're creating something bigger. And, another example are the cases here in the UK where despite a very generally conservative judiciary and difficult, expensive to litigate country, you see how one case that was challenged, one specific project for new oil and gas that was challenged on the basis that the companies hadn't calculated the emissions resulting from the burning of oil down the line, so scope 3. By doing that, by challenging that hadn't been calculated and informed, it has allowed many other developments in the UK, much more significant new areas of oil and gas to be challenged. So it's this combination of using sometimes just one specific smaller case that you win, and by doing that, creating an impact that is wider and that challenges the whole social license for oil and gas in a country. So these are a few examples. And as I said, I think we still have to understand better what's happening in China. There is a whole world of litigation there being brought by public prosecutors. The courts are preparing themselves. Judges are doing trainings and studying the science. So it won't take long for us to see thousands of cases also where you will see the courts interfering in activities that are highly polluting. But I think back to the issue of obstruction, which is, of course, the object of our chapter, it's important to understand also how these legal strategies have been increasingly used by companies to obstruct protesters or NGOs or even scientists. And we have a tendency to focus on the cases that are aiming to promote climate-aligned action and change. But it's also important, and we put this as an important question for research and investigation to take place, where there is also understanding of how companies and governments, and the US government now is a clear example of using litigation, using legislation to stop action, to stop investigations, to stop litigation. And we have to therefore have this full understanding of how law is used in all directions to understand risks and also prepare for situations where you will have such type of, we call SLAP litigation, so strategic litigation against public participation, or also arbitration claims brought by companies against states. So have the full picture is necessary to understand how to stop obstruction, but also where further obstruction might come.
Speaking of which, you have this case study about the US and looking at, barriers to regulatory and litigation efforts. Other than the ones you just touched on, are there any other, what are some of the other barriers that you're seeing in the US that are like helping to inform this, like how do we prepare for obstruction, actually using legislative and judicial tools against climate action?
So, okay, let me start with in terms of SLAPs. It will be interesting to understand that this is both growing, but also there are ways in which regulation can protect citizens and organizations, right? And so we see, for instance, in the EU, in the European Union, the EU has adopted an anti-SLAP directive. So it's quite recent. It's from 2024. And this directive aims at protecting public interest defenders. And what it does is that will then enable the early dismissal of what could be an unfounded claim and protect citizens from abusive claimants. And but using that now, we are, so it's pending, but Greenpeace, after it's suffered this really terrifying lawsuit in the North Dakota court that Greenpeace was ordered to pay over $600 million in damages for supporting protests against the Dakota Access Pipeline. Greenpeace brought a case in the EU using this directive. So it reminds us that whereas the litigation can be a stage for this battle from all sides, and that you end up having this really risky dependence on what a jury or what a court, what one judge will decide, by having legislation that protects citizens, you have a much safer, broader protection in place. So the EU has many examples like that of still being able to pass legislation that will protect the interests of public defenders and then if you extend to disclaiming and other protections in like more broadly.
Yeah, I know it'll be interesting to see what happens with that.
And you did an amazing investigation of that case. Of course, I listened to all your episodes. I'm a big fan.
Oh, awesome.
I thought it was excellent how, of course, I read this case from the court documents and what legislation is being used, but also to have that story told from what the individual's experience and the injustice that was so patent there is so important. So yeah, absolutely important, your work. I really love it.
Thank you. Thank you. Yeah, I know. Well, I just was so shocked that they were not allowing any recording or anything in the courtroom. So it was like, wow, okay. So if we're not there, we're really not going to know what's happening in this case, you know? And it was so egregious. I think it really shook our reporter, Ellie. I mean, she's like a criminal justice reporter and has reported on activist movements and surveillance and all that stuff. So it's not like she is naive about abuses of the criminal justice system or the courts. But she came back from that being like, wow, like I don't have any faith at all in the justice system. It's like,
I think losing faith in the justice system is something we want to avoid, because ultimately, when nothing works, you still should have that option. And you see, it was a terrifying result there in North Dakota, which was, I think, also not completely surprising. But then you have a higher court. You can go to the EU. There are so many options. And that's what's, I think you can always have some hope when it comes to the law, that there will be a court, there will be a jurisdiction where that message will be understood.
yeah. Okay. So shifting gears a little bit, I want to talk about the regulatory side of the legal question, and have you kind of run down what are some of the regulatory levers that can be pulled to deal with climate obstruction, to prevent it as opposed to punish it later.
So in the chapter, we discuss, in addition to some of the legislation and the litigation, we speak about government investigations. And the advantage of these investigations is that they can move faster than courts, and they can also produce evidence that then can be used in other instances. So we look closer at 3 examples, one in the Philippines, one in the US, and one in Europe, where investigations have been used directly looking into the issue of obstruction. The case in the Philippines is really interesting, because we have there the Philippines Commission on Human Rights, which is a body that is an investigatory body, doing this investigation as a consequence of the terrible hurricane that took place, hearing survivals, hearing experts and scientists, also inviting the companies to speak. And very few companies spoke, but they did invite all the companies. And what they did was, through this really thorough investigation on the human rights harms of corporate conduct, they concluded that the carbon majors had engaged in obfuscation and obstruction. So this becomes in itself a case that is backed up by huge amounts of evidentiary material that others have been able to use as a demonstration of the obstruction. And there is a very detailed description, testimony of how the companies that were investigated were obstructing historically the science and policy on climate. And then the other 2 examples that we use in the chapter are one in the US, actually, in 2021 and 2022, where a series of subpoenas and hearings revealed that there is a delay strategy to expand oil and gas. And it makes it clear that also it's against clean energy investment. And what this investigation does, it really helps shifting that political space, right? You see that even if it's just an inquiry, it shows quite quickly with robust evidence that that situation is taking place, and then others can follow with that. And finally, we looked at an investigation by the European Parliament. This was a few years ago already, in 2019, where there was really public spotlight on denial and corporate messaging, with the politics of transparency becoming very clear. And that in itself motivated the European Parliament to further legislate. And that's, again, an example of how an investigation then also can motivate new legislation, better legislation that will increase accountability and improve transparency. And by doing that, avoiding obstruction.
Awesome. Can I have you define greenwashing and climate washing? And then talk about what are some of the regulatory possibilities for dealing with those 2 problems?
Sure. So we usually use greenwashing and climate washing a bit interchangeably. In general, what we mean is examples of when the public has been misled. The public being general public, investors, or even regulators about climate impacts, plans, or progress. So when it's specific about misleading on climate issues, we tend to talk about climate washing, whereas when it's misleading about green in general, we speak about greenwashing. But overall, greenwashing, climate washing are short terms to define the misleading of public by corporates or also by the government. They're quite similar, but climate washing tends to be used when it's more specific about misleading the public, investors, or regulator about the climate impacts. And greenwashing is broader when it's misleading about any green credentials.
Got it. And what are the sorts of regulations that can be passed to deal with this? I mean, I know that these things often become the basis of litigation claims, but what are the things that can be done to put guardrails on or maybe prevent climate and greenwashing ahead of time?
Yeah, so, well, there are several laws and regulations that exist to protect and empower consumers and investors to prevent greenwashing. And these tend to be found in many countries. That's why it's also been an area where we've seen so much litigation, because most countries have some law or mechanism to protect consumers from misleading, any sort of lying. You have less legislation that is specific about greenwashing and even less legislation that is specific about climate washing. But there's usually at least some protection through consumer law, through anti-fraud law that will be potentially used to stop false or misleading advertisement. Now, whether you need that specific legislation that is only dealing with climate washing is a question that is discussed. Some say that would be helpful because there are some, technicalities about carbon offsetting and how you announce your net zero and whether you're counting on technologies that don't exist for your net zero pledges. And some would argue that in order to fully protect consumers from this type of false or misleading advertisement, you would need some specific legislation. And then in the meantime, while that doesn't exist, we can still rely on the general consumer protection laws that will be available. And what's also quite good in this case is that there are two more advantages. One is that usually the evidence needed for these cases is not so complex. So if a company claims that they are investing heavily on renewables and you have on their books, they will publish themselves that they invest 0.0 something percent, you can make that argument quite easily. And then also another advantage is that in some countries, you might not need to bring a judicial case to a court. There are also some administrative regulatory agencies and bodies that will deal with misleading information, and these tend to be quite specialized and quicker. So you might have quicker results in stopping greenwashing and misleading through these routes.
You touch on this in the chapter too, but I feel like it's becoming a big issue. But how do you deal with the fact that there is this increasing push to claim that like any effort to deal with greenwashing or climate denial or climate washing is censorship? And where is that line between, protecting free speech and holding people accountable for spreading misleading information?
Yeah, that's a very difficult part of the chapter, and one that's in itself, you could have a whole book about that.
Yeah.
So some core tensions that we identify, and this one between speech and deception is one where on one hand, you need and you have robust protections for speech, and these are important, and they coexist with this long-standing authority to regulate misleading. So where courts draw that line is what we're seeing now. And there's a whole margin of subjectivity, of uncertainty against. But it's just the fact that you don't want to lose those protections for free speech. And at the same time, you don't want to allow any misleading claim to be made. So that's a really good example of maybe what is the place? How do you mediate those things? Well, I think courts have a really important role in drawing that line. So it's one of those that I think it's just, you can't not have that tension, and it confirms the importance of specialized bodies or courts in resolving.
Yeah, I think that we're going to see in the US a Citizens United type claim around the liability cases. I've been saying that for a while, and it's moving in that direction. I mean, that's the main argument that they're pushing, is this idea that because falsehoods were told in the service of shaping policy, that they're protected political speech. And all the First Amendment attorneys I've talked to think that argument is going to win.
Mm-hmm.
Which is really scary, because then you end up in a situation where, the Supreme Court in the US right now is a joke. So it's a scary time to think about a court in a major developed country affirming that lying about climate change is protected speech. I'm just curious, what you think about the impact that would have on potentially other litigation around misleading claims.
Yes. I think there's something interesting that each one, let's say, opposing views on this will see themselves as the owner of the truth, right? So you have this really crazy conversation where you could see that someone who is completely against climate protections or even challenging climate science will very much agree with someone who is a climate scientist and protecting climate policies on one issue, which is, well, we all have the right to say what we think. The protection for free speech is absolutely important. And, they will both say that they are doing that, right? And so it's a very complex situation, because that's what free speech is to an extent. And this is what I was saying about drawing the line is how courts will deal with what is political advocacy, what is paid lobbying, what is backed up by robust science. And this is where I think we are very lucky that we have the IPCC. In other areas, you don't have a world effort of bringing thousands of scientists who agree on the level of certainty of the state of the art of the science, right? What other areas that exist? Not any other area you would have that. So I find that when we get to that really unresolvable in principle moment where both claim the truth and maybe, both truly believe that they have the truth, both sides, then you go to the science and it's all there in one place. The IPCC scientists, they spend years reading paper by paper, consolidating, and it's not that they are making new analysis, right? They're just reviewing what exists, and it's science that has been peer reviewed, that comes from the leading universities, that has been, published in journals. So it can't get better than that. And what then the last challenge of this story is that you will have to get the courts to go through the science and understand what is being said. So it will be, in many of these instances, that the decision will have to be made by judges that will have to engage with the IPCC science. But if they do, the answer is there. So I do have hope that these issues around free speech will be resolved by robust science that already exists.
That's it for this time. Make sure you're subscribed so you don't miss an episode. You can find more on this season, including transcripts and lots of related articles and background information on our website at drilled.media. You can also sign up for our newsletter there. Our producers for this season are Martin Zaltz-Ostwick and Peter Duff. Our theme song is Bird in the Hand by Forenoun. Our cover art is by Matthew Fleming. Our First Amendment attorney is James Wheaton with the First Amendment Project. The show was created, written, and reported by me, Amy Westervelt. Thanks for listening, and see you next time.